evening, Mr. Speaker. I rise to offer my humble support to my learned friend and colleague, the Honorable Attorney General, and to support this amendment of the Power of Attorney Act. Mr. Speaker, as far back as 1932, on the 14th of May, to be exact, Guyana enacted legislation which provides the statutory underpinning for the operation of power of attorneys or deeds of power of attorney in Guyana. It is now, for the first time, getting an update, a much needed update. Mr. Speaker, a power of attorney is not a person, it's a deed. The person who acts is really called an attorney. What happens and what happens is that someone, in effect, trusts and gives to someone, so they're called a donor, as is set out in the legislation. So that person gives the power to someone else to act in their stead. It is akin to having an agent or a proxy, someone to act on your behalf to do that which you are able to personally do. So, Mr. Speaker, the foundation of the power of attorney is really to allow the average citizen to have someone act on their behalf in their stead. Power of attorneys are a very common legal document, Mr. Speaker. It is estimated that more than 10,000 are filed annually in our court system. They're filed in the deeds registry, and that's how they become a deed. They're executed before, as it stands now, before a notary public. That notary public would usually be required to ascertain the identity of the person who is before him. There is, and there was, no legal obligation on the part of the notary to verify the identity of the person who is being authorized, meaning the person who is now going to exercise the authority of the donor of that power. So there was never a requirement under the law that that person make himself known. Power of attorneys, Mr. Speaker, the deeds, they can be used in many instances and they can take many forms. We should recognize that it can be general, which means it can be for anything that you can do. So you can make a general power of attorney to authorize someone to act, to do anything that you could do, which is to vote at company meetings, to sell property, to collect rent, to transact business at the bank. It could range through all of that. Or it could be specific for something, only one act. For example, to collect rent. Something very specific that the power of attorney can do on your behalf. Now, as the Honorable Attorney General mentioned, there are also deeds that are done on the statute. Like the deeds registry, you can have someone receive transport on your behalf by a specific statutory regime that avoided the Power of Attorneys Act that required registration in a particular format or form. Uniquely, Mr. Speaker, power of attorneys or the deeds that are made can be irrevocable. If given for consideration and satisfies certain matters of law, it can be made to be irrevocable. That would mean that that person is able to continue, the person who you've given this power, even perhaps in circumstances where you don't want them to any longer. It poses a problem. Revocation is an issue and has to be set aside as if it were a contract. But, Mr. Speaker, we cannot, even with the dangers of what a power of attorney can do, Mr. Speaker, it is a necessary aspect of ordinary life for most citizens. Guyana, it is no secret, Mr. Speaker, has many persons who are overseas. They still have property and need to conduct business and do other things in Guyana, and they would usually authorize someone to act on their behalf. Now, the troubles which were identified by the Honorable Attorney General in one single case that reached the Caribbean Court of Justice, Mr. Speaker, has regrettably replicated itself, and every practitioner knows that there are much more matters in the court where power of attorneys have been used as instruments of fraud. They have been forged, they have been faked, and they have been used against the wishes of the donors of that power. So it is open to abuse. Now, how does the abuse happen? The most frequent way is that, of course, it is forged or it is fake. And the person who is purporting to act on behalf of the donor is not, in fact, known to the donor and should not act on behalf of the donor. So we have a situation, Mr. Speaker, which is quite simply this. A very useful and important legal document, which is a deed, is susceptible, because of the legislative underpinning that existed, it is susceptible to improper interference. Now, Mr. Speaker, the choice would be we can discontinue them altogether. That wouldn't make much sense, respectfully. It is a document that is far too useful. But what we can do, and what was suggested by Justice Jamadar in the Caribbean Court of Justice, and in fact other members of the court, and what the Honorable Attorney General has highlighted, is we need to make it better, which means we need to take that 1934 statute and drag it into 2022 so that the instrument that it creates can be effective in 2022, but more importantly, it can be secure for those who will wish to employ it. Mr. Speaker, the legislation that the Honorable Attorney General has recommended to the House speaks very simply. What it does can be divided into two, perhaps three headings. One is it provides how it can be made, meaning who must be present and what must they do to meet the requirements of the law. So it says that the person giving the power, referred to as the donor, he must be present with two forms of identification. It says the donee, who is the person receiving, must also be present and must also have two forms of identification. So what it does, which had not been in the law before, is it now requires the recipient of the power to be present and to provide identification. So that's one aspect. Secondly, it says the notary or the magistrate, they must now be satisfied and take copies of the identification documents provided. For example, as it would be in the data page of your passport, if that's what's being used. You must provide, they must receive pictorial representations, which means they got to see your picture along with your ID so they can ascertain who you are. What must then happen is the notary himself must make a record of these things. Now, if it is done where one person is overseas and one person is in Guyana, each notary must discharge those obligations. And each person, be them the recipient of the power or the giver of the power, must also satisfy those requirements. Then, Mr. Speaker, we get to the other part. Once it is received, and there are two witnesses that must sign as well, once it is received by the notary and he stamps it, he must take those documents and make it a part of what it is that he is concluding, which is the deed itself, be it a general power, a specific power, or one of the statutory powers provided for as the Deeds Registry Act does. Now, what happened before was that the legislation we had said exactly that if it were general or specific powers, then it had to be in compliance with the law as set out in the Act, but not any of the other forms of deeds of power of attorney that exist under statute. So the Deeds Registry power of attorney for receiving conveyance did not have to meet the requirements of the Power of Attorney Act. That is no longer the position. All statutory powers must now meet the requirements. Then we get to the part, Mr. Speaker, where this has to be registered in the Deeds Registry. The Deeds Registry must receive these documents and receive passport-size photographs as well, so that they can register all of this. When the this is done in the registry. Now, Mr. Speaker, it's been a notorious fact that persons in the Deeds Registry have imposed, if you like, requirements in an effort to preserve the sanctity of deeds of power of attorney by requiring, for example, that you update it annually, that require that before you use it in a transaction, they would require that you update it. Mr. Speaker, there is in the old legislation, there is no such requirement. But because the documents were so important and because they were so fraught with danger, the Deeds Registry has, without statutory authority, in fact, been insisting on this in an effort to make the document more secure. The legislation and the bill proposed to this House would no longer be necessary. The people in the registry and the staff of the registry and the registrar no longer have to take it upon themselves and impose conditions which they ought not to, and which are not provided for by law, in an effort to preserve a very important document. This law now provides to them the framework within which they can comply, within which they can request, and within which the document itself would have sanctity. And better security is now added. Now, there are, as the Honorable Attorney General alluded to, there are persons who would take a power of attorney, be the recipient of the power, that would give them the right to sell property, and they sell it to themselves. They sell it to a family member, or they sell it to someone at an undervalue, for example. And this especially happens in the case of fraud or forgery. So now there is a specific offense created if you do that. So now when you take someone's authority to act on their behalf There are now specific things you have to be aware you could be liable for. You cannot obtain financial advantage to yourself. You can't use it in that way. You can't use it to cause loss to the person who's giving it to you. So basically, that's what it was for. That was one of the highlights of the Todd case that the learned Attorney General alluded to. And that is, in fact, the most common complaint that is received, that persons are turning up, they have power of attorneys, and they act on behalf of persons, and they use it to secure advantage, personal advantage to themselves. Now, any person who would be the attorney who acts on behalf of the person, they would be liable to a summary conviction and a fine of $5 million and imprisonment for 5 years. Mr. Speaker, practicing attorneys will tell you that $5 million fine and 5 years imprisonment is on the higher end of the scale to which there are fines and imprisonment. So, Mr. Speaker, that gives an indication of the seriousness with which this is being treated, with the serious and obvious effort that is being given to protect the document and to protect the people in Guyana, the citizens who need to use it, and also those who own property and want to not have someone fake that document and fraudulently sell their property. Now, Mr. Speaker, if we are to take it from the position of where we are, it is not an overstatement to say that we have taken the document itself of a power of attorney and we have overhauled it, taking into consideration most of the common complaints or deficiencies, most of the dangers, and so far as a statute can do, we have eliminated or managed it to a position whereby the risk that those who wish to use it improperly, the risk that they take is now substantial and real. And it does not only cover those who are purportedly signing these documents to give the power and those who are receiving the power, but it now corrals the notary themselves, who will be the persons who stamp and authorize these documents. It now puts them on guard that they must heed the warnings of the law. They must make good their obligation. They must discharge their obligation. Because, Your Honor, we have a concept in law where if you are a bona fide purchaser, if you are not knowledgeable of or you're not tainted by the fraud, it wouldn't affect you. But the notary now has an obligation, and he can choose to either comply with the statute or not. But if he does not, even though the property owner may not be able to recover his property because of a legal principle, it does not mean that the notary cannot be sent to jail and cannot be fined. So although the principles that apply as to fraud can't be changed by this legislation, it puts on guard everyone who acts in the process. And as long as the persons who act as donor of the power, the recipient of the power, the donee, or the notary, and it would extend to those in the registry, if they do not meet those requirements, they are now substantial, statutory offenses created for which it will cost them not only a fine, but it will cost them their liberty. So there is imprisonment that goes with it. Mr. Speaker, with my humble contribution, I commend this amendment and I support the amendment as proposed by the Honorable Attorney General. Thank you.